Limitation for taking cognizance of an offence. So the word cognizance has not been defined in the procedural law, but the meaning of cognizance is derived from the number of precedents and judicial pronouncement. So it is not defined anywhere. Whatever meaning we get is from the judicial precedents, means judge made laws and all. The dictionary meaning of the word cognizance is to take account of. Please underline, taking notice of or to gain knowledge about something or to have a knowledge regarding something. If we see the legal meaning of the term cognizance. So it is the power of the authority of the court, underline, or taking judicial notice by the court of the law having jurisdiction or an action, matter, please underline, action, matter or cause for the purpose of deciding whether there is any ground for initiation of the proceeding and deciding of the matter or cause judicially. So the word cognizance means संज्ञान में लेना. So if there is no point, okay, no point under law, either action, matter or cause or purpose for dealing with the matter, then the court will not take the cognizance of an offence. For example, if you are charged with both 479 and 480, okay, so 479 deals with theft and 480 deals with of IPC, okay, 480 deals with robbery, okay. So you are charged with both the sections. So in robbery also there is theft, but robbery is when it is committed by more number of people, okay. So in that case the court will take the cognizance in either of the two offences, okay, not both the offences, because robbery is also a kind of theft. Now next, in the case of R.R. Chari versus State of UP, the Supreme Court held that the cognizance occurs when the court applies his judicial mind. Please underline the word judicial mind.
Yes, ma'am.
To the suspicious cause of action, but it is not necessary to take any indeed or formal action. So the main thing in taking cognizance is application of judicial mind. Please make a note somewhere. Application of judicial mind. Now according to section 515, for the purpose of this chapter, unless the context otherwise required, the period of limitation means the period that is specified under section 517 for taking cognizance of an offence. Now according to section 516, except as otherwise provided in this Sahita, no court shall take the cognizance of an offence of the category specified under subsection 2 after the expiry of prescribed period of limitation. So there is a prescribed period of limitation for taking the cognizance of an offence, and if the magistrate is not taking the cognizance within that prescribed period, then he cannot again take the cognizance of an offence. The period of limitation shall be 6 months. Please underline. If the offence is punishable with fine only. So if the offence is punishable with fine only, then it is 6 months. Then 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. So if the punishment for that is imprisonment for 1 year, then the time is also provided as 1 year. Next is 3 years if the offence is punishable with an imprisonment exceeding 1 year but not exceeding 3 years. So if the punishment is between 1 year to 3 years, then the time provided is 3 years. For the purpose of this section, the period of limitation in relation to the offence which have been tried together shall be determined with reference to the offence which is punishable with more than, like whichever is more severe punishment. For example, you are tried for 4 offences together. You are tried for theft, you are tried for house trespass, you are tried for criminal trespass, you are tried for criminal breach of trust. So in 4 of the, whichever the punishment is more, that will be the period of limitation for taking the cognizance of the offence. Okay? Hello?
Yes, ma'am.
Any doubt?
Yes, ma'am. No, ma'am.
Yeah. According to section 517, the period of limitation in relation to the offender shall commence on the date of the offence. Please underline.
Yes, ma'am.
So the period of limitation shall commence on the day of the offence. where the commission of an offence was not known to the person aggrieved by the offence or police officer, the first day on which such offence came to the knowledge of the police officer, whichever is earlier, will be considered as the first date of the offence. For example, if no one is knowing when offence took place, so on the day which the person got the knowledge that yes, the offence took place, that will be the first day or the beginning of the offence. So where it is where it is not known by whom the offence has been committed, the first day on which the identity of the offender is known to the aggrieved party will be the first date. For example, offence is also known, some murder took place, okay, but murder took place, but who did the murder, no one know. So the very day the person comes to know about the offender will be the first day, okay. In computing the said period, the day from which period is computed shall be excluded. For example, if I am knowing today, then today, the day for today will be excluded. It will be counted from tomorrow. Okay.
Yes, ma'am.
Any doubt?
No, ma'am.
Yeah. Now, according to section 518, in computing the period of limitation, the time during which a person has been prosecuting with due diligence another prosecution, whether in court of first instance or in the court of appeal or revision or against the order of the offender, please underline, shall be excluded. Provided that no such exclusion shall be made unless the prosecution relates to the same facts and is being prosecuted in good faith in the court, which from the defect of the jurisdiction or other cause of action, cause of like nature is unable to entertain it. Now, where the institution of the prosecution in respect of an offence has been stayed by injunction or order, then, in computing the period of limitation, the period of continuance of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded. For example, one trial is going in the lower court, but the High Court stayed the matter, stating that now the matter must be stayed and it must be decided later on. Okay, so in that case, the time for which the injunction was allowed or stayed by the High Court, that will be deducted. Okay.
Yes, ma'am.
Now, where notice of prosecution for an offence has been given, or where under any law for the time being the previous consent or the sanction of the government or any other authority is required for the institution of any prosecution for an offence, then the period of time in which the sanction was obtained will be deducted. Okay. Now, according to section 519, where the period of limitation expires on a day when the court is closed, the court take the cognizance on the day when the court reopens. So, if for example, if I have to take the cognizance of the offence today, but today is Sunday, so in that case, the next very date, they have to take the cognizance. Now, section 520, in case of continuing offence, a fresh period of limitation shall begin to run at every moment of time during which the offence continues. Okay, so if it is a continuing offence, then the period of limitation will again and again start. Any doubt?
Yes, ma'am. No, ma'am.